during the assault of the complainants. Accused 1 said he referred to the second complainant as a suspect because the second complainant ran away after he called him. On the other hand, the second complainant testified that he ran away because he did not trust the accused because of the way the farmers mistreat black people. The accused stated that the second complainant was not the first person to be put inside the coffin. They had on previous occasions put black people inside the same coffin after suspecting them of crime. They did this in order to scare the suspects, and none of these incidents were ever reported to the police. This gives credence why the complainant ran away when he was asked to stop. The conduct of the accused towards the complainant and the undisclosed black persons who went through the same ordeal goes against the spirit of the Constitution. The preamble to the Constitution provides, amongst others, for an intention to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. These are the rights I've already alluded to before. The complainants were badly assaulted, kidnapped, intimidated not to report the matter to the police. And without diminishing the seriousness of the accused's general conduct, the most appalling act by the accused was to put a living person in a coffin against his will under threats of killing him. They put the coffin inside the sealed dish and forced the second complainant inside the coffin. Whilst inside the coffin, they threatened to set it alight with petrol. They asked him how he wanted to die, quickly or slowly. The conduct of the accused was most dehumanizing and disgusting. These actions appear very clearly from the video evidence tendered by the accused. The pain and trauma that the second complainant experienced can only be imagined. He still lives with the consequences of the ordeal he was subjected to despite receiving counseling. He testified that he's afraid of going out and meeting people in public. The video evidence was tendered mainly to refute the second complainant's version of the assault.
le video yayiveze njena ukuthi kubonwe ukuthi bamzwise ubuhlungu kanjani.
The video evidence did not serve the purpose it was intended, but corroborated the second complainant's version of inhuman treatment.
Kodwa leyo video ayizange ibe khombe lo okungampela kodwa yakhomba ngalendlela yena umangaleli wesibili ngalendlela inhlungu izwe ngakhona.
Throughout their evidence, the accused maintained that they did nothing wrong and indicated that they did not regret their actions.
Kanti ngaleso sikhathi bukelwa le video bona bathi ababoni kuyiphutha nakhona abayisoli.
The only time that the court heard of any form of remorse on the part of the accused was during the evidence on sentence.
Ukuyisola kwabo babuveze ngaleso sikhathi kwemnase kufanele ukukhishwe isikwele.
They both indicated their regret in putting the complainant in the coffin and not taking him to the police.
Bathe bayayisola ukuthi bamthwala eposini bangamthwala umumhla epolice station.
As already indicated, accused number 2 further indicated that he regrets his actions because of the impact the case had on his family as well as the looming sentence.
Kodwa unumber 2 uthe uyisola njengoba ebona lemkana ngalendlela iphathe umndeni wakhe nakhona nesigwebo.
The accused gave evidence at the trial over a year since the assault and still indicated that they had no regrets.
Kanti bafike bazofakaza esikhathini esiphezulu kwenyaka namanje bona bathi abayisoli.
During the evidence of the complainant recounting the degrading treatment at the hands of the accused, accused number 1 threw his hands in the air, signaling lack of deference.
Kanti ngalesi sikhathi ufakazi buthulwa lana ulommangalo wesibili number 1 wase uphakamisa lezandla ukubonisa ukuthi lento akayikhathaleli.
The accused only indicated some form of regret to the probation officer after their conviction.
Lokho isola kwabo bakhombe kulo social worker ngalesi sikhathi icela ukuthi ikhulume nabo mayelana nesigwebo.
Contrary to their evidence during trial, the accused told the probation officer that, and I'm quoting from the probation officer's report, open quote, during the time they were incarcerated and awaiting their trial date, they had time for introspection and reflection to consider their actions towards their complainant, and they then realized that they did wrong to the complainant and they are remorseful about what happened and their part in the incident, close quote.
Bathe nasi bekhuluma no social worker ngalesi sikhathi bebhale babona bayayisola ngaleso sikhathi ngoba bayabona ukuthi bavalele bayabona ukuthi icala lihamba kanjani.
The statement is clearly at variance with the evidence before court.
Ihlangothi lomphakathi lethe icala elizwakalayo.
The evidence of the accused and their conduct during the trial clearly display a lack of remorse.
Kanti ngalesi sikhathi bekhuluma nokuyiphatha kwabo lokho kwabonisa ngalesi sikhathi bekhuluma ukuthi ababonisi ukuthi.
The court appreciates that in relation to the 2 counts of assault with intent to cause grievous bodily harm, there was no proof of the extent of the injuries sustained by the complainants, and the court accepted that this was largely because the complainants were afraid to report the incidents to the relevant authorities.
Kunamacala amabili lawa okushaya ngenhloso yokulimaza. Abuzanga bakhombe amanxeba ngenxa yokuthi ngaleso sikhathi babesaba ukuripota emaphoyiseni.
Further, the medical practitioner who examined the complainant some months after the incident did not corroborate the evidence of the complainant in respect of the injuries allegedly sustained by the second complainant.
Udokotela wabahlola emveni kwenyanga kanti ukubona kwakhe udokotela kuhambelani nangalendlela bakhulume ngokuthi balimazwe ingakhona.
However, the evidence before court indicates that the seriousness of the offenses far outweighs the mitigating factors and the personal factors of the offenders.
ubukhulu balecala budlula lokuyingengela lokushwelezwa kwabo.
The conduct of the accused fuel social division and racial tensions.
Lo kuyiphatha kwabo kubonisa ukuba nentliziyo ezimbi nokuba nenzondo kulabo kwabanye abantu.
In our society, there are increasing acts of racial intolerance and racially motivated crimes.
Kanti lobona ngalendlela beyiphathe ngakhona bayenza ukuthi ukuzonda kwabo bona uzonda abanye abantu kwande.
Accused number 1 is only 29 years old and accused 2 is 30 years old.
Number 1 uneminyaka ewu-29, u-2 uneminyaka ewu-30.
The accused are relatively young persons who spent most of their lives in a democratic South Africa during the period when serious efforts are being made to create and advance a society that is envisaged in our constitution.
Kanti basise bancane baphila kuleli lizwe esiphila kulona la kulwana nokuthi leli lizwe lishintshe abantu babuye bazwane.
The conduct of the accused confirms that a lot still needs to be done by the state, the public and the courts as well to ensure that those who disrespect our Bill of Rights and the Constitution as a whole are brought to book.
Lokho umthetho ufanele usebenze kanzima kanti nezinkantolo ukuthi laba abayenza njengabo bafike bajeziswe.
Thus the court has a duty to safeguard the rights of all citizens as enshrined in the Bill of Rights.
Ngoba inkantolo inamandla ukuthi ifanele iwalokuze kuwonke umuntu ukuthi abantu bangaphuli umthetho.
The community must be able to sense that the courts are seriously striving to maintain peaceful and safe living conditions.
Umphakathi ufanele ubone uphile impilo elula ejabulisayo.
For the reasons stated, I'm going to impose the following sentences.
Kuloko esingitshilo ngizokhipha isigwebo ngendlela elandelayo.
May the accused rise. In respect of accused number 1, I hereby sentence you as follows. In respect of count 2, that in respect of assault with intent to do grievous bodily harm to Mr. Delton Sithole, the first complainant, is 3 years imprisonment.
Number 2 zonikezwa 3 years ukushaya uDelton Sithole.
Is accused number 1.
Number 1.
Thank you. In respect of count 3, relating to the assault with intent to do grievous bodily harm to Mr. Victor Rethabile Mlotshwa, the first complainant is 3 years imprisonment.
Nokushaya uRethabile Mlotshwa 3 years.
Count 4 in respect of kidnapping is 5 years imprisonment.
Lokuduna 5 years ebalele.
Count 5 attempted murder is 7 years imprisonment.
Lokuzama ukubulala 7 years ebalelwe ngaphakathi.
Count 6 intimidation is 6 years imprisonment.
Lokuthusela umuntu 6 years ebalele.
The sentence imposed in respect of count 3 is ordered to run concurrently with the one imposed in respect of count 6.
Lesi sigwebo saku count 3 sizohamba nase count 6.
The sentence imposed in respect of count 4 is ordered to run concurrently with the one imposed in respect of count 5.
Kanti lesi sesiqala le number 1 ku count 4 izohamba le count 5 isigwebo sakho.
4. In respect of accused number 2, I hereby sentence you as follows. In respect of count 2, relating to the assault with intent to cause grievous bodily harm to Mr. Delton Sithole, the first complainant, 3 years imprisonment.
Number 2, ukushaya uDelton Sithole kuzawuba 3 years ebalele.
Count 3, assault with intent to cause grievous bodily harm to Mr. Victor Rethabile Mlotshwa, the first complainant, 3 years imprisonment. Count 4, in respect of kidnapping, 5 years imprisonment. Count 5, attempted murder, 7 years imprisonment.
Count 5 kuzawuba 7 years evalelwe.
Count 6, intimidation, 6 years imprisonment.
Lokuthusela 6 years evalelwe.
Count 7, defeating or obstructing the administration of justice, 3 years imprisonment.
Lokulahlekisa ikhonto ukuze umthetho ungaboni ukuthi kwenzekeni kuba 3 years evalelwe.
The sentence imposed in respect of count 3 is ordered to run concurrently with the one imposed in respect of count 6.
Count 3 khona sizohamba ne count 6.
The sentence imposed in respect of count 4 is ordered to run concurrently with the one imposed in respect of count 5.
Count 4 isigoma sakhona sizohamba ne count 5.
Accused number 1, you are hereby sentenced to 16 years imprisonment, 5 years of which is suspended for a period of 8 years on condition that you are not found guilty of any offenses, of the offenses you convicted of during the period of suspension. You are effectively sentenced to 11 years direct imprisonment.
Kanti isigwebo saka number 1 kuzoba 16 years bese ususpendwa lesinye iminyaka e6 kanti khona manje yena unumber 1 kusho ukuthi kufanele ayoyenza iminyaka e11 evalelwe.
Accused number 2, you are hereby sentenced to 19 years imprisonment, 5 years of which is suspended for a period of 8 years on condition that you are not found guilty of any offenses you convicted of during the period of suspension. You are effectively sentenced to 14 years direct imprisonment.
Number 2 yena uzawenza 14 years ngoba isigoma sakhe 19 years bese suspendwa uzoyenza isigoma esenza 40 years evalelwe ngaphakathi.
Accordingly, your bail is hereby revoked.
Kanti ibail zabo
There's no.
The state will further apply that the court considered the non-parole order in terms of section 276(b)(1 of the Criminal Procedure Act. I have not yet informed counsel about it because I was not aware of it.
Can we just take a break and how long will you need for that?
I'm ready, madam. I'm not sure about counsel.
I'll be in my chambers and you'll advise me as soon as I'm ready. The court will adjourn.